Good evening. It's 9:30, or rather 9:31, the 19th of June, 2021. For the record, I will say I do not acknowledge Juneteenth as a holiday, not because I do not respect the spirit or the sentiment of the intention, but because the considerations of what presumably identifies it as a cause of celebration, I believe are not entirely accurate. And I'm more concerned that the historical context was never actually reflected on appropriately. For those who know, they understand that Abraham Lincoln, who later became President of the United States, ended up being availed of the advantages of local political office based upon an alleged service he provided during a time of unrest associated with Indians. Specifically, a tribe was in its course of migrating from one area to another. They had been told that there had been some hostility in their area, and if they had gone to another area, that there was open grazing land, they would not be subjected to the kinds of travails they were in the manner they were in the place that they were used to. It required them to go through what was at that time identified as the state of Illinois. And in the course of that, there was contestation. This was associated with a time frame during which the equivalent of the state army had been called up in order to defend the people of Illinois against Indian raids and marauders. It was reputed that Abraham Lincoln served as some sort of officer in a reserve unit, and while he personally never saw battle, there was an incident involving capture of some Indians, and apparently he was accorded a commendation for treatment that was not commensurate with what would have been allowed to a man in his position, and by virtue of not being as extreme as he could justify because of the context and what was otherwise permissible, he was given a special consideration, and in association with that was able to acquire his land grant in the state of Illinois. Now, you could say this is a story that's not accurately reflected, especially in consideration of the time frame during which I ended up learning about it. It's not the kind of thing they teach you about in grade school. But this is the understanding I have of my own exit from the state of Illinois the last time I was there and what led me to Texas. And that's why the information that has come my way this evening is very disturbing. At some point in time in 2017, I offered myself as an expert witness in a case involving a woman and two children at the time that were minors, as well as in consideration of the fact that she had one adult child that was not with her at the time frame during which I met her. The youngest child was a boy child, spent most of the time with his father in the course of what was understood to be a custody proceeding, at least on her part, a custody proceeding and a divorce proceeding. Girl child was with her most of the time. The boy child was with the elder male child, with the father most of the time. During the course of meeting her, and first being a witness to her divorce proceeding and custody ordeal, I came to understand that by the letter of the law, she and her children were being trafficked. I offered myself formally as an expert witness in her case and went through the appropriate process by which to do so. I understood and believed that my history as a journalist covering issues up to and including in connection with human trafficking, my prior work in public health, including in compliance, and my consistency in terms of addressing matters related to human trafficking while also following through on an investigation, qualified me as an expert witness. And so I submitted my CV and references in a formal process connected to her proceeding to the attorneys for the other side and had it put on the official record. At certain points after that, her case and matters related to her case ended up being connected to not only frivolous litigation, but litigious actions that grotesquely abused the judicial process and had far reaching ramifications up to and including today. Sometime after that, I submitted another motion to the court as I was involved in a concurrent process representing myself pro se. I invoked an element of the Texas Military Code, and in the course of so doing, ended up addressing matters in a more comprehensive manner than that as a mere, or rather very important, expert witness. Prior to this, I had submitted an affidavit in consideration of another matter in another state. I was requested to submit an affidavit based upon my travel abroad, but also what was understood about my history, in consideration of matters related to what could be understood to be the causes of childhood migration from Central America into the United States. I submitted a formal affidavit to attorneys in San Francisco at their request. My understanding is after contacting them, there was no formal action in connection with my specific affidavit that I submitted at their request. Nonetheless, I did submit it and I would have stood behind it were it to have been engaged. I was informed it never was. This is an important matter. In that affidavit, one of the things I discuss is my personal witness while I was in another country that I did not provide actual testimonial evidence of or testimony as a witness to having encountered it myself in the United States, but understood that my observations of it in another country were based upon my understanding in consideration of what I had been witness to in the United States. It specifically concerned the use of burner phones, as they're called, or rather, temporary cell phones, including cell phones that are not given to somebody based upon their own identity. A temporary phone, they call a burner phone, that can be used in commission of acts related to drug trafficking or drug dealing, but they can also be used in acts of human trafficking. One of the things I was witness to and subjected to myself was an understanding that in the foreign country to which I offered this testimony or offered this affidavit, I personally had been subjected to, but also had been witness to, a process whereby, in order for one to acquire a cell phone in that country, I was told at least, that one had to register their SIM card with a local law enforcement ministry in order for them to be able to track against the use of burner phones and illegal activities. This was in the early and mid part of 2015. But I will say that I had many years before been witness to this very situation as well. And one of the things that became concerning to me was the recurrent use of and access to what were understood to be free phones distributed to homeless people, including homeless people that were on food stamps. My understanding is these phones were available up to once a year. And if you got one year and you lost it or something happened to it, you could not get one again. But you could get one of these free government phones, and then, perhaps, once you made the money with it, as I was witness to, you could get a burner phone, including at the local convenience store, which you would only need for a short period of time, and then you would be able to discard it on your way. Why is this a concern right now? It's a good question, don't you think? Because one of the things these phones say when you get them, and you actually read the instructions if you do, is a lot of these burner phones have in there a notation or a notice that at any given time they can switch networks without any forenotice and without telling you. At any given time while you're using that phone, they have liberty to switch service without any forewarning and without any confirmation. Now, I personally have been subjected to this. How it engages with or through alleged law enforcement is a very serious matter. I also think the consideration of being in a border zone and having to deal with Transnational telecommunications is one that we have not been very well apprised of, and I believe it is manipulated, including by and in connection with infiltration of law enforcement, specifically connected to acts of human trafficking. I'm also concerned that it may well even be being abused by members of the alleged judicial branch of government. And if you do a filing, if you make a legal filing on your own behalf, or if you're a witness and agree to be a witness in a case, you have to provide certain information legally: your address, your telephone number. Every one of those witness lists is going to have your phone number on it. Yours may not be the only one on that list at any given time. If you file on your own behalf, especially because you've been denied any sort of attorney, or for whatever reason you're representing yourself pro se, your phone number is on every filing. If you're not an attorney, you don't have access to the same kinds of security that an attorney has. That's why it becomes very disconcerting if somebody decides to try to engage you in derivative litigation without going through to the letter of the law what is legally required in order to do that. But it's also very important to make a distinction between what is considered professional conduct by members of the judicial branch of government with each other, because every attorney that files also has to put their phone number on there. We're dealing with something very important at this time. It's come to my attention that there have been a number of public comment periods available, including in connection with the Federal Reserve. Among those public comments are two that have the closure of their public comment period on July 12th, 2021. This is a very important date for a number of reasons. As a matter of fact, I just found a report that identifies how information in what is represented as a piece of legislation passed in 1992 is of direct relevant concern, referencing not only a report that was published on July 12th of 2007, but associating the elements of the report with a piece of legislation that discusses 15 years periods. That means this July 12th is going to be 14 years since that report, a year before the 15 years after that report was produced. It makes it a very important time frame. But it also brings up a very significant consideration that I've had for a long time, especially here in the state of Texas, concerning the Impact Texas Drivers Program. I've been concerned that the Impact Texas Drivers Program is being used in acts of trafficking, specifically of young drivers, including young drivers under the age of 18, but specifically young drivers between the ages of 18 and 24. By law, when the program was implemented, there was a requirement that there be 3 different elements: one for drivers under the age of 18, one for drivers the ages of 18 to 24, and one for drivers 24 and above. My concern, however, is that in consideration of various priorities that are more explicit than anybody acknowledges and certainly reports publicly, that there was a decision made to not engage the adult drivers program. And so anybody over the age of 24 that needed to acquire a license in the state of Texas, since this program was put into effect, was required to qualify in the process of obtaining a certificate that they had fulfilled the requirements of the driver's program so that they could obtain their driver's license with people ages 18 to 24. If you're 18 to 24, you are not legally old enough to run for Congress. That makes a difference. I've contended for several years that this program is in blatant violation of the law in Texas and that there are harrowing implications. And I'm on the record and publicly stated that when they allowed for a congressional representative from northern Texas to be appointed as the National Director of Intelligence without rectifying this problem, that they were exposing themselves to very serious charges. To this day, there has been no rectification or even acknowledgement of the problems with this specific paradigm. My major concern is that the Texas Impact Drivers program is based on a comparable program in the state of California. And even though the publicly accessible information about the origins and the implementation of the California program demonstrate, or rather reveal, that its structure and implementation is considerably different than the one in the state of Texas, my concern is that there has been illegal interstate activities, including interstate commercial activities, specifically exploiting the California and the Texas drivers programs for young drivers. There's no reason for this to actually occur at the level it has been. We are now going on 4 years since the state of Texas was, by its own law, required to have a separate adult drivers program. But if they allowed for adult driving to be illicit and decided to try to hide it in a database that was filled with young drivers between the ages of 18 and 24, and or allow for another form of even more illicit commingling by virtue of being in the database at all, including in connection with people below the age of consent. And my concern is that what they've been doing is using that not only to launder money, but to literally traffic people in association with the acquisition of their first driver's license. My major concern is that this information that I just acquired concerning the small business administration in this country and certain legislative action taken in consideration of the small business administration in this country reveals a process connected to certificates issued on pooled securities for terms of up to 15 years. That would be a good time to get a certificate connected to pooling of a security in order to support financing for a small business operation to be flipped 15 years later around the time somebody's attempting to acquire their driver's license. And that's exactly what I believe they've been doing. And in the course of that, they have been attempting to engage in egregious violations of the Constitution in order to entice or extort people, including young people, to engage in illegal activities. And have instead decided that what they're going to do is penalize young people for acting badly. And in order to try to placate themselves and attempt to condition younger generations of Americans or future Americans into acquiescence. Well, once you demonstrate some behavioral problem, or once the stress gets too much for somebody else to determine you have not been performing up to their expectations, they're going to provide you with medical assistance for your emotional or behavioral problem. And so now we got people getting their first driver's license while they're on drugs. And somebody is trafficking them in connection with their drug use and their driver's license for all kinds of other business activities that are not being appropriately disclosed. How do I know? 103. There was a report released by the Federal Reserve System apparently this year in May of 2021 discussing debit cards and transaction fees. And somebody did some analysis. The 1240 is bad enough, just so you know. I wasn't anywhere near old enough to even learn how to drive a tractor for someone's farm at the time that got set up, and I was in good faith, attempting to do what I needed to do to make sure that any allegations that there might be some potential for a cyber attack to occur based upon misrepresentation of information entered into a database. Well, I was certainly old enough to run for the Senate or even the presidency when somebody decided to change that 1240 to a different metric. But it's been appearing all over the place, and it just showed up on the Federal Reserve report concerning transaction fees for debit cards. See, debit cards are also the kind of thing you can get a pay as you go account hooked up without having to register anybody's name, and it's real easy to give somebody a burner phone and a prepaid debit card and a schedule and tell them to go from one place to another and then to hedge on their transportation options. That's exactly what you've been doing. This isn't just about transaction fees for debit cards. They made it very, very clear when I was allowed to stay inside. One of the big problems they've been having from the 80s is some people thought that for their fine services on those pass-throughs, they were entitled to a certain fee for every transaction. And when they didn't get the rates they liked, well, it became hard for them to process all those applications you had to keep filling out over and over and over again because somehow you just didn't qualify. Yeah. We'll continue this conversation